We're going to call it out of order. State of Nevada versus Pernell Graham, 26 PC 031238. And we'll bring him inside. Yes.
More private.
Please.
Yes,
we are.
They're not going to hear.
We have their mics.
Oh.
Good morning, Mr. President. You were arrested for 6 counts of sexual assault against a child under the age of 16. 1 count of battery by strangulation with intent to commit sexual assault. 2 counts of lewdness with a child under the age of 14. 1 count of sexual assault. 1 count of open or gross lewdness, first offense. 1 count of kidnapping, first degree. 1 count of school employee or volunteer in a position of authority, 21 or older, engaging in sexual conduct with a pupil aged 16 on or older on school property, at a school activity, or on a school bus. 1 count of child abuse or neglect of substantial bodily or mental harm. 15 counts total. The court did find probable cause existed for your arrest. I do need to hear from the district attorney's office today regarding your custody status, and then we'll hear from the public defender.
Thank you, Your Honor. In this case, the state is requesting monetary bail in the amount of $350,000 with high-level electronic monitoring as a release condition if he's able to make that bail, as well as a no-contact order with the alleged victim and a no-contact order with any minor children under the age of 18. Reviewing this report is an incredibly concerning case, Your Honor, involving the sexual abuse of a 14 to 17-year-old child over several years. What is even more disturbing is that the defendant was an educator and a coach of the victim. The victim, who is now 17 years old, disclosed multiple instances where the defendant forced her to perform sexual acts with him that, like I said, began when she was 14 years old. The defendant clearly used his position of authority over her as a teacher and flag football coach to abuse the victim for his own sexual gratification. She describes several acts of abuse in great detail that were covered in that police report, which involved forcing the victim to masturbate him, performing fellatio on him on multiple occasions, spanned a period of 3 years. The defendant also, according to the allegations, the disclosures performed cunnilingus on the victim and also penetrated her vagina with his penis. During the first incident of abuse, the victim detailed that he picked her up from her residence, took her to his residence, where he then forced her to take shots of alcohol before he assaulted her. He then threatened her that if she ever told anyone, he would hurt her or her family, or have someone hurt them. She also indicated he offered her money to stay quiet, making multiple cash payments to the victim that totaled approximately or almost $5,000. Detectives were able to review records of those transactions on the victim's phone, providing further corroboration with the allegations. The victim also provided detectives with various items, including alcohol, that she said that the defendant had provided to her as gifts. So in the totality, the defendant took advantage of a child using his position of authority in this case, and it's also concerning that at the time of his arrest, he was currently working in another school, and again, in the supervisory or authority position at the time of his arrest. So based on these troubling allegations case, that we state believes the defendant posed a significant danger to the community. Additionally, with the serious charges he's facing, if he is convicted of these charges, he's looking at multiple life sentences. That is a significant punishment, and obviously the court can consider that as straight out of Valdez-Jimenez's decision as into the decision of the court as far as defendant's risk of flight based on the significant punishment he is facing. His risk assessment score is a -1, which is low, with no prior criminal history, but the seriousness and troubling nature of these allegations certainly cannot be overstated. The state clearly believes he is a danger to our community and potential flight risk. So with that said, we do believe we have proved by clear and convincing evidence that there is no combination of non-monetary conditions that would ensure the defendant's appearance at future hearings and ensure the safety of the victim and the community. Because there are no less restrictive alternatives, bail is requested as previously stated with release conditions should the defendant be able to post that amount of bail. The defendant cannot or does not meet this monetary condition of release, and the court's order should serve as pre-trial detention. And I'll submit that.
I disagree with the state that the only condition that should be imposed here is the $350,000. I believe, given the record that we have here, I do recognize that the allegations are serious. However, Mr. Graham is not a flight risk, and that's one of the considerations that Your Honor should take into should be determined in determining the amount of bail. And in this case, Mr. Graham indicated to me that he was born in the United States, as in fact the TCR indicates he was born in Chicago, Illinois. He has lived here since 2019. He has a verifiable residence. He has a cell phone. Additionally, he has his mom and siblings, his brother actually residing in Las Vegas. So he has significant ties to our community. And right now, he has no conviction whatsoever, not even a traffic ticket, not even a misdemeanor. He is basically zero across the board. And to assume that he is going to be a flight risk simply because the allegations are serious is really not supported by the information we have here. Given that he was born and raised in the United States, there's no indication that he is going to leave the jurisdiction. And I think in this case, if you place him on high-level electronic monitoring, that is sufficient. As far as safety of the community is concerned, obviously he has been accused of very serious crimes, but it's a crime of opportunity. You remove that opportunity and the community is safe. You place him on high-level electronic monitoring, which monitors his whereabouts 24/7. That danger, that concern of the state is eliminated. I believe imposing a no contact with anyone who is under the age of 18 is also an order that Your Honor can impose, other than $350,000 bail that the state is asking for. Your Honor, he cannot afford bail. In fact, he cannot even afford $50,000, even though he has an annual income of $90,000. Because the reason why he cannot afford any bail is because, as you can see from the second page of the financial affidavit, he has no savings. He has no money in the bank. And in fact, he believes he has lost both jobs. Mr. Graham indicated to me that he has been a teacher since 2013. He has a bachelor's degree as well as a master's degree. And given that his SOL score is -1, I believe imposing stringent conditions such as high-level electronic monitoring, no contact with anyone who is under the age of 18, not to have any contact with the alleged victim, not to go near any school, are conditions that Your Honor can impose that will ensure the safety of our community. That's my request at this time, Your Honor.
Mr. Graham, the court has to be concerned today with whether you're an individual that poses a risk of danger to the community, who poses a risk of danger to victims in the community, and whether or not I believe that you're likely to reappear in court. This court does have concerns today about all of those factors. The allegations contained in the police report that you picked this child up from her home, took her to your home, plied her with alcohol, and then committed sexual acts on her is very disturbing to the court. And it wasn't just one time, this happened on multiple occasions over multiple years. As her coach and as an educator in the community, it's extremely egregious. While you scored a -1 on the pretrial risk assessment tool with absolutely no prior criminal history that the court is aware of, I have taken that into consideration today. I've also taken into consideration your ties to the community, reviewed your financial affidavit, and I've taken into consideration as well your financial ability to post bail. But the court does find that the district attorney's office has met their burden for further findings by clear and convincing evidence that monetary bail is necessary and appropriate as the least restrictive means available to this court, not only to ensure community safety and victim safety, but to ensure your reappearance in court. I am going to set bail today in the amount of $350,000. High-level electronic monitoring. No contact with the victim. No contact with any minors under the age of 18. And a stay-away order from all school properties. A detention order was not part of this court's findings today. I will be hearing next Monday.
March 26th at 8:30 in Department 2.
Thank